CPC as well as on the Limitation Act. And taking you forward from all those topics, today again there's a fascinating topic. Is Article 134 of the Limitation Act a complete bar to the auction purchasers' rights after 1 year? This would also have somewhat wrapping within the Securitization Act and large number of affairs where these properties are auctioned. We are delighted that Sir has accepted our invite. And thank you, Sir. And over to you.
Okay, because your voice is not as audible as it should be.
So you can start.
Yes. Good evening, all of you friends. Today we have to deal with a subject in the Limitation Act. I will give an example. A is the decree holder. He got a money decree against B. He filed an execution petition. Attached to the properties of B, the judgment letter, and put it in court auction. The property was auctioned and it was purchased by a stranger C. Now C paid the money into court. So he has done all that is at his end. Then what else is to be done? The property should be delivered to C, for which he cannot file an execution petition. Execution petition was already filed by A against B. What C has to do is to file an application to get delivery. Under which provision? Under Article 134 of the Limitation Act. What does Article 134 say? I think you have got that notes where all these provisions are there. Article 134. For delivery of possession by a purchaser of immovable property at a sale in execution of a decree, 1 year, when the sale becomes absolute. When does the sale become absolute? Rule 92 of Order 21 says so. How it becomes absolute? Before going to Rule 92, I will say when a court auction sale of immovable property takes place, it can be set aside on 3 grounds, on 3 provisions as per. One is Rule 89 after depositing the money. 2, under Rule 90 on the ground of material irregularity or fraud in publishing and conducting the sale and also irreparable injury. 3, by the auction purchaser saying that the title of the judgment letter is not perfect. These are the 3 grounds on which an auction sale can be set aside. What does Rule 92 say? Rule 92 says, where no application is made under Rule 89, 90 or 91, or where such application is made and disallowed, the court shall make an order confirming the sale, and thereupon the sale shall become absolute. Where no application is made under Rule 89, 90 or 91, or where such an application has been filed and it is dismissed, the court shall make an order confirming the sale, and thereupon the sale shall become absolute. When does, under Article 134, the period of limitation run? When the sale becomes absolute. When the sale becomes absolute, you will see under Rule 92, provided that where the property in execution petition, execution of a decree is pending, final the disposal of any claim, that we are not concerned for the time being. Rule 92. This is the provision. Suppose no application is made under Article 134 of the Limitation Act, or if it is made, it is dismissed on the ground of limitation. 1 day, more than 1 year and 1 day. It cannot be condoned because Section 5 of the Limitation Act says an application, an appeal or application other than an application under any of the provisions of Order 21 of the Code of Civil Procedure, the court may extend the time. For a suit or an execution petition, time cannot be extended The court has no power to extend time. So, an application under Article 134 is to be filed within 1 year when the sale becomes absolute, not when the sale certificate is issued. You may see under Rule 94, 95, 94 of Order 21. Certificate to the purchaser. When the sale of immovable property has become absolute, the court shall grant a certificate specifying the property. Specifying the property sold and the name of the person who at the time of sale is declared to be the purchaser. Such certificate shall bear the day on which the sale becomes absolute. That is a date. Delivery of property in the occupancy of the judgmental, Rule 95. Where the immovable property sold is in the occupancy of the judgmental, or some person on his behalf, or some person claiming under a title created by the judgmental subsequently to the attachment of such property, and a certificate in respect thereof has been granted under Rule 94, the court shall, on the application of the purchaser, order delivery to be made by putting such purchaser or such person in possession. So when we read Rule 94, it can be seen that the time starts that immediately after the sale is confirmed and the sale becomes absolute, a certificate in respect thereof has been should be granted, and delivery of property will take place only after a certificate in respect thereof has been granted. But when we read Article 134, what is required is that when the sale becomes absolute, the time starts. There is a slight conflict between these two provisions. And there are decisions, which I will refer to shortly, that for the purpose of filing an application under Rule 134, no sales certificate need be produced. That means when the sale becomes absolute, the time starts. When no matter whether the time the sale certificate is issued 1 year thereafter or 6 months thereafter, that will not be excluded for the purpose of computing the period of limitation under Article 134 is the settled position of the Supreme Court in various decisions. There is a decision where it was doubted and it was not referred to a larger bench. But now the Supreme Court in 2023 has doubted its correctness and referred to a larger bench. Now another question arises: what will happen if no application is made under Article 134 within 1 year, or if it is made and dismissed on the ground of limitation? Can a suit be filed? Is the question. There are two decisions of the Supreme Court that Article 134 is a quick remedy, and after the expiry of it, a suit can be filed. There are other decisions of the Supreme Court where say that suit will not lie. That question also is referred to in Bhaskar's case by the Supreme Court, Justice Oka, division bench, to a larger bench. It is pending. Now we have to. There are various decisions of various high courts taking different views, and the litigants find it very difficult. Therefore, the Law Commission worked on it suo moto and prepared a report. But unfortunately, since the chairman has been appointed as a Lokpal, we could not upload it on the website. Now the new Law Commission has taken charge. They may go through it, and if they approve it, that will be uploaded, and if the parliament accepts it, it will become the law. Now we have suggested several amendments on that in the draft. Now it is only a draft. Yes. Now other provisions which are relevant for the purpose is section 65 of the CPC. When immovable property is sold in execution of a decree and such sale has become absolute, the property shall be deemed to have vested in the purchaser from the time when the property is sold and not from the time when the sale becomes absolute. Title vests in the purchaser on the date of sale. Suppose the sale took place on 1/1/2023. The sale becomes absolute. Or the sale can be made absolute only after 60 days because the court has to wait for the application under Rule 89, 90 or 91. When such an application is filed, it should be disposed of. Then only the sale will be confirmed, and then only the sale will become absolute. So it is not that date. Suppose it was made absolute after 6 months on 1/6/2023. When does the auction purchaser get title? Whether it is on 1/1/2023 or 1/6/2023. Definitely on 1/1/2023 because Section 65 CPC says that the title will vest in the purchaser from the time when the property is sold and not from the time when the sale becomes absolute. But for the purpose of making the application under Article 134 of the Limitation Act for getting delivery of possession of the property, it is necessary that the sale should be made absolute. So time starts from that date. But that does not mean that the title has not vested. Title vested in the purchaser on the date of sale. Now, we have seen Rule 92, we have seen Rule 92, 93, 94, 95, certificate to the purchaser. Then we have to see Section 15.4 of the Limitation Act. 15.4 speaks of exclusion of time. The Limitation Act provides for various things. One is extension of time, the other is exclusion of time, the other is time not running, then the other is exclusion of time on various grounds, and certain point of time the time will not run. Likewise, various provisions are. Section 15 is an exclusion provision, and 15.4 says, in computing the period of limitation for a suit for possession by a purchaser at a sale in execution of a decree, the time during which a proceeding to set aside the sale has been prosecuted shall be excluded. What does it start? In computing the period of limitation for a suit for possession. Which is that suit for possession? So Limitation Act was enacted, was a 1908 Act. Now it is reenacted. It is consolidated and amended in 1963. Even in 1963, this wording is there, where a suit for possession by a purchaser at a sale. But none of the decisions of Supreme Court refer to 15.4 of the Limitation Act. None of the decisions. I have given the citations also. You may go through it. I'll refer to that and briefly explain because our time is limited. I may Can I take Mr. Vikas 15-20 minutes more so that I can finish it today itself. Now another important provision is Section 27 of the Limitation Act. Extinguishment of right to property. At the determination of the period hereby limited to any person for instituting a suit for possession of any property, his right to such property shall be extinguished.
So you
So
can
generally
continue,
speaking,
you
pardon?
continue till the session, till you finalize it. Time is not a.
So that I can finalize it, otherwise it will be very difficult.
Yes, sir. Yes, sir. You can finalize it.
Yes. 27 of the Limitation Act says at the determination of the period hereby specified for filing a suit for possession of any property, his right to such property shall be extinguished. What is the general rule under the Limitation Act? Limitation Act only bars the remedy, not the right. That is a general rule. This is an exception to that. Because in property, immold property and the right regarding immold property should not be kept in suspense. There must be an honor for the property. It is visited with several liabilities and rights. Revenue is to be collected. So there must be an honor for the property. Whereas I lend money to you, I did not file the suit within 3 years. So my suit is barred. I cannot file a suit to recover the money. But if your money comes to my hand, I can appropriate it towards the borrowed debt. Or we can agree, which is valid under Section 25 of the Contract Act, such an agreement to repay the amount. That agreement also can be executed, can be enforced. But because the right is not extinguished. The right to receive money by the creditor is not extinguished. Right continues, remedy is lost. That's all. But in the case where your property is trespassed upon by a stranger and he started possessing it adversely with all the incidents of adverse possession, neck we, neck clam, neck precari, that is adequate in continuity, extent, and authority. He continued it for 12 years. You cannot file a suit against him because he has perfected title by adverse possession. A recent decision of the Supreme Court In Ravinder Kaur Grewal, the Supreme Court said that on perfecting title by adverse possession, the adverse possessor gets title and he can file a suit even against the real owner, because there was a confusion regarding that in the Supreme Court. Several decisions say that the perfecting title by adverse possession can be used as a sword, cannot be used as a sword, and it can be used as a shield. But in Ravindra Kaur Grewal, by a three-judge bench, it is clearly laid. All the other decisions were overruled, and it is clearly laid that adverse possession, the title acquired by adverse possession, A is the owner, B adversely possessed for the required number of years, then B becomes the owner. A's right is lost. That is section 27. That is an exception to the general rule that the limitation only bars the remedy, not the right. The right itself will get extinguished. So I am using this section 27 for the purpose of interpreting Article 134. Why? Because a title to a property can be extinguished only in the manner known to law. I am the owner of a property. My property can be, I can sell it, I can gift it, I can otherwise deal with the property, assign it, or otherwise lease it, mortgage it, where I can forfeit my, I can assign my title, whatever title I have got, leasehold right or mortgage right or absolute right, whatever right I have got, I can assign it. Then my title is lost. Or where my property is sold in court auction, or in revenue recovery sale, or by land acquisition. These are all the known methods for losing title, or otherwise under section 27. These are the methods. A property title cannot be lost by the expiry of 1 year under Article 134. It never says so. It only says that your application for delivery of possession will not be maintainable after 1 year, because you can make an application for delivery of possession within 1 year under Article 134. But that does not mean that a suit will not lie. Then the hurdle is section 47 of the limitation. We will see section 47. Many of the lawyers interpret, judges interpret this way. Section 47 is a bar. No, my opinion is it is not. Section 27 says all questions arising between the parties to suit in which the decree was passed or their representatives and relating to execution, discharge, or satisfaction of the decree shall be determined by the court executing the decree and not by a separate suit. My argument is that it is not regarding execution, discharge, or satisfaction of the decree. It is my title. I am ventilating my grievance regarding title. I am filing a suit on title. How is it barred? It can be barred only under section 27. 27 will not apply because Article 134 speaks of only an application, whereas Section 27 says of a suit. There are three proceedings contemplated under the Limitation Act: appeal, application, and appeal. These are the three categories of cases dealt with under the Limitation Act: appeal, application, and suit. Suit, appeal, and application. These are the three categories of cases. So, what is spoken to by Section 27 of the Limitation Act is a suit for possession. What is spoken to by Article 134 is an application for delivery of possession. Here, after the expiry of 1 year under Article 134, I am filing a suit on my title. I need not say somebody trespassed, because after the 1963 Limitation Act, I need not prove dispossession. I need not prove the date of dispossession. Only the burden of proof is on the defendant to prove adverse possession. That was the whole change made by the Limitation Act 1963. By the 1908 Act, every plaintiff in a suit for recovery of possession or based on title should prove that he was in possession within 12 years. That means the whole burden was on the plaintiff to show that he was in possession within 12 years, that is, it is not barred by limitation. Whereas under the 1963 Act, when title is either admitted or proved, the plaintiff need not do anything. He can sit tight, keep quiet. He need not lead evidence when the title is either admitted or proved. Then the whole burden is on the defendant to prove that he has perfected title by adverse possession. That is a possession under the limitation. So a suit for possession is comes under which provision? mainly under Article 65, 64 and 65. There are other provisions also that deals with the different aspects, redemption, recovery of possession, etc. So a suit for possession under Article 65 of the Limitation Act. Article 65 also I have put in the notes. You may see. Article 64 for possession of immovable property based on previous possession and not on title, when the plaintiff while in possession of the property has been dispossessed, 12 years, date of dispossession. That is based on possession. I will give an example. Sorry. A is the owner of the land. B trespassed upon that property and ousted A, and B continued for a few years. While so, C dispossessed B. B can file a suit against C under Article 64 because he has got a better title than C. C has no title. Whereas B cannot file a suit against A because under Article 64 because no suit will lie against a true owner. That is a position. That is Article 64. You may see Article 65 for possession of immovable property or an interest therein based on title. Possession of immovable property or an interest therein based on title. 12 years. When the possession of the defendant becomes adverse to the plaintiff, that is a starting point. It is not when the dispossession took place. So, in a suit based on title, the plaintiff need not prove any dispossession or date of dispossession. The whole burden is on the defendant. Of course, if the defendant says that the plaintiff's title is disputed, the plaintiff has to prove the title. That's all. He need not prove anything else. Then there under Article 65 Clause C, where you may see, where the suit is by a purchaser at a sale in execution of a decree, where the judgment debtor was out of possession at the date of sale, the purchaser shall be deemed to be a representative of the judgment debtor who was out of possession. What is this provision? Where the suit is by a purchaser at a sale in execution of a decree, when the judgment debtor was out of possession at the date of sale, the purchaser shall be deemed to be a representative of the judgment debtor who was out of possession. On the date of sale, the judgment debtor is the owner of the immovable property sold in court auction. Suppose he was not in possession on the date of sale. Then the purchaser can file a suit based on his title, and he shall be deemed to be a representative of the judgment debtor, because on the date of when the sale takes place, the judgment debtor was the owner. So, by a fiction, the auction purchaser is given the right to file a suit. After the court auction sale, the title passes to the auction purchaser on the date of sale under section 65 of the CPC, and therefore, after court auction sale, the auction purchaser can file a suit on title. That is a possession. Now, we will see section 47. We have seen section 47. 47 speaks of uh, all questions relating to uh, all questions relating to forgot between the parties to uh, relating to execution, discharge, and satisfaction. That is execution, discharge, and set. This is not relating to execution, a suit. It is not relating to discharge. It is not relating to satisfaction of the decree. The auction purchaser files a suit on title after the period provided under Article 134. Where does the suit? Where is the suit barred? Now, explanation 2 of section 47 is mainly relied on. For the purpose of this section, a purchaser of property at a sale in execution shall be deemed to be a party to the suit in which the decree was passed. This is mainly relied upon to say that no suit will lie. Then B. All questions relating to delivery of possession of such property to such purchaser shall be deemed to be questions relating to execution, discharge, or satisfaction of the decree. These are the two explanations. Explanation two clauses A and B are relied on to say that no suit will lie. Section 47 is a bar. My submission is that this is on a wrong premise. What is explanation 2A is that a purchaser shall be deemed to be a party to the suit. Therefore, he is binding, and all questions relating to execution, discharge, and satisfaction of the decree shall be decided in the execution proceeding itself. That's all. Then all questions relating to delivery of possession. When a suit is filed after the period provided under Article 134, it is not for delivery of possession. It is suit based on title. That difference nobody takes note. Then Section 54 of the Limitation Act, which says about a suit for possession by an auction purchaser. That position has not been considered, that provision has not been considered by any court in any of the known decisions dealt with on that aspect. So these are the provisions. Now we have to see that the Supreme Court will consider it. I will refer to some of the judgments and I'll make my argument on different lines. It is for you to answer. I want certain questions to put. What will happen? One question is this. All right, an auction took place. Auction purchaser did not get possession. 1 year elapsed. He was abroad. He did not come back. 1 year elapsed. No application will lie under Article 134 thereafter. Suppose the court is to hold that no suit also will lies. That means all his rights have been lost. It is against the interpretation of Section 27, against Section 27, and therefore violative of Section 27 of the Limitation Act. It is violative of Article 15.4 also. Then let us assume that it is so. Then I will say the auction purchaser can defeat that situation and get possession. How? A, B, C. A is the owner. A is the judgment. Sorry, he is the judgment creditor. That is the person who is to get money, decree holder. Then B is the judgment debtor. C is the auction purchaser. C did not apply within 1 year. He did not file a suit also because the suit is not maintainable is advice given to him. And going through the judgments of the Supreme Court, he comes to the conclusion that suit will be a waste of time and money. Then, now he trespasses upon the property. Who? C, auction purchaser, trespasses upon the property and ousts the judgment debtor. What can the judgment debtor do? What is the remedy of the judgment debtor? He cannot file a suit for possession under Article 64 because he is not the owner. He cannot file a suit against the true owner. Who is the true owner? The auction purchaser. Going by Section 65 of the CPC, he gets title on the date of sale. So, under Article 64, a suit cannot be filed against the title holder for possession. So, B, the judgment debtor, even if his property has been trespassed upon by the auction purchaser, he cannot file a suit against him because the title vests the auction purchaser. He cannot file a suit under Article 65 because he does not have title. Then what is his remedy? Only under Section 6 of this specific relief act. That you may succeed. High-handedness. The auction purchase, the judgment debtor, that is B, succeeds in a suit under Section 6 of the specific relief act. After that suit is decreed, the auction purchaser can file a suit on title. There is no bar. It is provided in Section 6 itself. And that title suit will decide the whole issue. There also, title is a paramount thing. His right is not lost. So, going by that also, it can be seen that the right to file a suit is not lost. Now, what will happen if he trespasses upon? That means we are promoting lawlessness. Court has no law to help him. The interpretation of the court is that we are helpless. You cannot file a suit. He trespasses upon. How can the court punish me, the auction purchaser? They cannot. What action can be taken against him? No action can be taken except under Section 6 of the Specific Relief Act. So, does it mean that the law permits lawlessness? Law promotes lawlessness? Interpretation by the court promotes lawlessness? It should not be. Or the auction purchaser says, asks his friend, you trespass upon. You trespass upon. That is D, a stranger. A stranger trespasses upon. B. The judgmental cannot file a suit against him because he has no title. He has only possession. He can only file a suit under Article 64 probably. But he cannot then also the auction purchaser files a suit against that D. Which suit will be decreed? The auction purchaser suit. Then if his suit is decreed, can he not get possession? So does the law permits lawlessness? On the other hand, if the interpretation is that say, Article 134 is a quick remedy, and after the expiry of that period you can file a suit for possession, no provision is infringed. It is a misnomer, it is a wrong thinking that Section 47 of the CPC is a bar. It is not. On a close scrutiny of the provisions under Section 47, there is no such bar. But now the Supreme Court has to deal with it threadbare. And if the law commission, new law commission has been constituted 2 days back, if they agree with that report which we have prepared, draft, they may send it. Probably the parliament may, at its leisure, consider it. Anyhow, the matter has to be clarified. But my submission is that even without any amendment, even without anything else, by interpretational process, we can hold that a suit lies. Now, Article 65 provides for a suit for possession of immovable property or an interest therein. Now, two decisions of the Supreme Court, even a person has having no title to immovable property can acquire title by property by perfecting title by adverse possession. Ravinder Kaur Greva, I have given the citation. Then P.T. Munichika Reddy, what is the possession under the 1963 Limitation Act is discussed. Then comes the difficulty. To get delivery of the property purchased in a sale, whether the court auction purchaser is necessary to make an application under Article 134, or whether after the expiry of the period of 1 year specified therein, whether he can file his suit, is the question. Now, some of the decisions you may see. Pattam Kadar Khan versus so and so. Pattam Kadar Khan versus Pattam Sardar Khan. This one decision, which was doubted, but it was not referred to. Larger bench. Now all these questions are referred to larger bench by the Supreme Court. Pattam Kadar Khan, the Supreme Court did not doubt. Now you may note the decisions. Parliament, by reducing the period for filing an application under Article 134 to 1 year, it was originally 3 years. Why it was reduced? Not to punish any litigant, not to punish any title holder. You complete the execution proceedings within a time, otherwise you will surely file a suit. Only to finalize the proceedings quickly. Balakrishnan versus Malayandi Konar and Pattam Kadar Khan versus Pattam Sardar Khan, where it was held that Article 134 is a quick remedy, and on failure to avail such quick remedy, the law relegates the purchaser of sale and execution of a decree to the remedy of a suit for possession in a regular way. Bhaskar versus Ayodhya Jewelers. That is a decision where Justice Oka referred to larger bench. Supreme Court did not doubt the correctness of the view regarding maintainability of separate suit at the instance of the purchaser of immovable property at a sale in execution of a decree. However, the Supreme Court in Lakshmi Narayana Rao versus New Premier Chemicals took the view that remedy of the purchaser is to get delivery and make an application and a separate suit would not lie. This K.R. Lakshmi Narayan Rao versus New Premier Chemical Industries, that is 2005-9 SCC. So there are conflicting decisions of the Supreme Court. Three decisions I referred to. UN Mitra on the Limitation Act and Prescription. 16th edition, volume 2, page 2730. You may note, I, I think I have given that citation. If it is not given, you may note. UN Mitra on Limitation Act, it is not there in the notes. UN Mitra on the Law of Limitation and Prescription. 16th edition, volume 2, page 2730. I will read a short paragraph for your information. The question of maintainability of a suit by a purchaser at a sale in execution is dealt with thus. The right of the court auction purchaser to file a suit for possession against a stranger in possession at the date of sale within a period of 12 years from when possession of the defendant becomes adverse to the plaintiff still survives under Article 65C. For a stranger is not a party to the suit, and Section 47 has no application, only that auction purchaser in a suit in such a case shall be deemed to be a representative of the judgmentor who was out of possession on the date of sale. Why then the right of the auction purchaser to seek delivery of possession from the judgmentor who was in possession on the date of sale be reduced to a farcical period of 1 year under Article 134? This is a question posed by the author. This is unfair, unjust, and anomalous. This legal conundrum is due to the failure of the draftsman of the Code of Civil Procedure Amendment Act 1976 to study the impact of the amendment of Section 47 on the right of the auction purchaser to seek the delivery of possession from the judgmentor who was in possession on the date of sale. The matter requires legislative interference. This is what UN Mitra says. UN Mitra says that while CPC was amended by Act 104 of 1976, 47, Section 47 was amended considerably. At that time, they did not take note of the conflict between Article 134 and Section 47. And also, they did not take note of the impact on the amendment of Section 47 on the right of the auction purchaser. Therefore, according to the author UN Mitra, legislative interference is necessary. Section 27 of the Limitation Act, we have seen that the right is extinguished when a time for filing a suit is expired. But this is not a suit. Article 134 is an application. So expiry of that period will not oust the right, will not extinguish the right of the real owner under Section 27 of the Limitation Act. Suppose the auction purchaser did not file an application. After the expiry of the 1 year, the auction purchaser forcibly ousted. What is the remedy? I have referred to now and I have given an answer. So therefore, my submission is that, and also I'll give some of the tips on the decisions. In Harnandri Badridas versus Devi Dutt Bhagavati Prasad, that is 1973 to SEC, where the main issue was whether the auction purchaser in a sale in execution of a decree has to file a suit to get delivery or whether he can move an executing court with an application for the said purpose. This was the question where the Supreme Court said that he can move an application under Article 134. And in that process, his court said that suit is not the remedy. It did not say that after the expiry of 1 year under Article 134, a suit is barred. That is not the question considered. This is the only decision which is put against us. A different view was taken in Pattam Kader Khan versus Pattam Sardar Khan, that is 96.5 SEC 48, where it was held. See the note, the dates. Court auction sale was confirmed on 7/8/84. However, the sale certificate was issued only in 89 November, that is after a period of 5 years. The court auction purchaser filed an application for delivery of property on the date of issue of the purchase certificate. Objection was raised by the respondent that the application was barred by limitation. In Pattam Kader Khan, it was held that it is not necessary to produce the sale certificate, but the date of confirmation of sale at the sale becomes absolute is the relevant date. You need not produce the sale certificate for the purpose of maintaining an application under Article 134, and therefore in Patangadhar Khan's case, in that case it was held that the application is barred by limitation. Lakshmi Narayan Rao versus New Premier Chemicals. Sale was confirmed in 1973. The sale certificate was issued only in 1980. Auction purchaser did not apply for delivery of possession within 1 year. He filed a suit in 98. There it was held that a separate suit will not lie. One of the reasoning is that the schedule appended to the Limitation Act having provided as for a specific provision prescribing limitation for filing an appropriate application for recovery of possession of the property in the possession of the judgment debtor. It is idle to contend that Article 136 of the Limitation Act would apply even in relation to thereto. Is one of the points. And there I am saying my respectful submissions that there it is misinterpreted. It is not a suit for recovery of possession under Article 134. It is not an application for recovery of possession. It is an application for delivery of possession. Who is to deliver? The judgment debtor has to deliver. It is his duty to obey the decree. Since he is not obeying the decree, the auction purchaser has to file an application. So first of all, obey the decree. And a person who has violated the decree cannot say that all these contradictions. And having regard to our findings, that is the case. No, that is another point. Balakrishnan versus Malayandi Konar held that the remedy under Article 134 is a quick remedy, and the party who fails to file an application for delivery within time can have the remedy of filing a suit for possession based on title. That is quick remedy. Now in Bhaskar, you may read paragraph 15, 16, 17, 18, 22, 23 and 24. I am not reading now because it will be boring. You may leisurely read it and understand it. Now this is the position. Therefore, you have to find out whether a suit lies. My opinion is that a suit is perfectly maintainable. Now that question is before the Supreme Court. Let us hope that the Supreme Court will come forward with an appropriate solution. Now, for your information, we have suggested an amendment in the draft Article 134. We added an explanation. Expiry of the period of limitation or dismissal of an application on the ground of limitation under this article shall not affect the title of the purchaser or bar his right to have remedies under law based on his title. We suggested this explanation to be added. Further, in Article 134, the time from which the period begins to run for the words when the sale becomes absolute, the following words shall be substituted. The date of issue of sale certificate to the purchaser at a sale in execution of a decree under Rule 94 of Order 21. So it is a date of issue of sale certificate. If these two amendments are carried out, all these confusion will vanish. Even otherwise, on an interpretational basis, it can be done. But interpretation by courts differ. Various high courts differently interpret. And the Supreme Court also, we have seen in the four decisions which we have referred to, various views have been taken. Now, anytime the view may change, the interpretation may change. The legislative provision is the court judgment is not a substitute for legislation. So there must be specific and clear provision of law rather than a judgment of the Supreme Court. Judgment of Supreme Court is all right, but that is not a substitute for a provision because now there is a two-judge judgment. Tomorrow, three-judge bench may take a different view. Later, a constitution bench may overrule it. Everything is in suspense. Whereas a specific provision of law is made, it will operate. So when there is a doubt, as UN Mitra pointed out, it is a wrong understanding by the legislature, or they did not take care while amending CPC. Section 47, that there will be arise a conflict. Therefore, that is to be corrected. Judicial legislative interference is required. If that isn't done, everything will be solved. Till then, interpretational process will continue, and several persons may win, several persons may lose. Everything is in a nebulous state. So my submission, my personal view is that a suit lies. Now it is for you to interpret. Over to Vikas. I have finished in 1 hour, less than 1 hour. Vikas,
So there is a long question in the chat box.
yes, what is that question?
Sir, good evening.
Good
A filed a suit for recovery of money
Ah,
on B and C. C remained ex party. His whereabouts is not known. A obtained a decree and brought the property of BC for sale. Sale is conducted subject to the disposal of the claim petition filed by D. C came into the knowledge about the suit and execution proceedings in claim petition proceedings before the sale is confirmed. C intends to remit the total amount, including the poundage and other expenses. But A is contesting as per CPC amount has to be deposited within 30 days of sale. Now this is more than 2 years old. C got the knowledge and claim petition proceedings. Then what is the remedy of C if he wants to pay?
so I do not understand the question at all.
The question is too long. I was also thinking.
Yes,
I can check it out if we have any question on the YouTube. Just hold on. YouTube.
that question cannot be answered straight away.
That's true.
Because that question, to assimilate and understand that question, it takes time.
You will have to formulate.
Yes. Any other question?
No, sir. That was the only question.
Is there any other point to be clarified on this subject?
No, sir. No question have been received. I was just checking the YouTube as well as on the chat box.
Have they understood it?
We expect, and those who want the note shared by sir, that is available on the website of Beyond Law, and they can connect with that and also watch the video. It will be good for them. Thank you, everyone. Stay safe. Stay blessed.
Thank you. Because again, after a gap of time of 2 years,
Yes, sir.
I
That's
was in the law commission, I could not do.
true.
There, what happened was that I was working hard every Saturday, Sunday. I was doing homework. I have not gone out. I was doing homework. I was typing. I was reading. I was doing work. UCC, I have drafted. Several other CPC reports I have drafted. And that has not come to light because the chairman had gone as local. But I've worked hard day and night.
That we know. So and those who want to watch sir sessions, they can watch Beyond Law CLC and also Justice KT Sankaran's own YouTube videos for more updates on very intriguing and interesting topics of CPC, Specific Relief Act, and Limitation Act. Everyone stay safe, stay blessed. And tomorrow we discuss about fundamental rights by Justice Manju Goyal, a former judge of Delhi High Court. Do join us at 6 p.m. Thank you, everyone. Stay safe, stay blessed. Namaskar.
Namaskar. Thank you.